afternoon. As you settle in, I would like to welcome you. Feel free, feel at home, and share the link with another person who may be interested in listening in this afternoon. Apologies for starting this a little bit late. We were running a few technical glitches, but that has hopefully been resolved, and we are live now. We are streaming live on YouTube and our social media handles. Good afternoon, and my name is Gabriel Achai. I'm speaking to you live from the East Africa Law Society House in Arusha, Tanzania, and it's a beautiful Thursday afternoon. I hope you are well and safe wherever you are. If you're in Nairobi, I hope you're keeping warm, and if you're in Tanzania, I hope you're hydrating because the heat wave is running across the region. So this afternoon, ladies and gentlemen, we converged to discuss a very pertinent topic that is sweeping the continent and East Africa in particular, and that is navigating business and human rights in the digital age. And today we'll be discussing challenges and opportunities for legal practitioners in East Africa. As you know, the digital age has not left anything unchecked, and business and human rights is one of those things that the digital age is continuously checking. And this afternoon, we are honored to have Ms. Sarah Ngachi, who is a legal officer at Thomson Reuters Foundation, and she supports the pro bono legal services in Africa and manages funded projects on AI and human rights in Africa. She also supports the foundation's work on responsible business conduct. Her expertise is in business and human rights, international justice and human rights. And prior to joining Thomson Reuters Foundation, she was an International Justice in Africa Fellow based at Amnesty International's East Africa Regional Office, where she researched on human rights in conflict, corporate accountability, and advocacy at Africa regional mechanisms. Sarah is an advocate of the High Court of Kenya and a member of the East Africa Law Society, and she holds a Bachelor of Laws degree from Moi University and a Master of Laws degree from the University of Western Cape, South Africa, and Humboldt University, Berlin. And Sarah has been around this space. She has moderated and spoken at very high level conferences in Africa and beyond. And Sarah, this afternoon, we are profoundly honored and exceedingly humbled to have you moderate this session. And you have 2 hours to run the session. And best of luck, and looking forward to a wonderful session. Thank you so much.
Thank you so much, Gabriel, and good afternoon from wherever you're joining. As Gabriel has introduced me, my name is Sarah, and it's an honor to speak and listen to the panelists describe their experiences and their work on this area of business and human rights and in the digital age. As Gabriel has mentioned, I work at Thomson Reuters Foundation, and apart from the work of bolstering resilient independent media and access to law, our responsible business work also focuses on AI ethics and AI human rights. And what we do is we work with civil society organizations and journalists to capacity build them on AI and human rights, especially with regard to accountability for tech companies. So this is a topic that's very close to our hearts at Thomson Reuters Foundation, and personally, having done a number of research pieces on generative AI and freedom of expression in Africa. And it's an honor to have such a wonderful list of panelists who will be discussing their experiences and their work on this area. Today, we are joined by Ms. Nasanga Aki, who is a senior consultant at IBIS Consulting. We are also joined by Dr. Hannah Muzee, who is a PhD holder and a researcher at CIPESA, as well as Ms. Njile Bwana, who is a co-managing partner at KKB Attorneys at Law. And we will be starting this conversation today with Ms. Nasanga. And Ms. Nasanga, I hope you can hear me and you're ready to kick off with your very elaborate presentation. on the evolution of business responsibilities in human rights. And just to take us a bit in terms of history on how we got to the current state of business and human rights in Africa, or even rather internationally, starting with the UN guiding principles and the state duty to protect, the corporate responsibility to respect and the access to remedy, as well as bringing it closer home to East Africa. What does this mean for East African legal systems, and what does it mean for tech companies operating in East Africa? Ms. Nasanga, over to you. Apologies, we cannot hear you. You're muted.
Sorry about that. Am I audible now?
Yes, you are.
Very well. Thank you very much for the introduction. And I would also want to take this opportunity to thank the Law Society, the East African Law Society, for yet another invitation to contribute to this important and timely discussion. I think for some context, I would say that over the years, we have gotten familiar with the physical operations of corporations, and we have gotten to understand the extent of their power, their influence over ourselves as well as over our different governments. We somewhat had gained an understanding of the human rights violations that they perpetrate, be it land evictions, be it environmental pollution. We knew all these things. We could see the human rights violations. And so over the years, we have devised ways of surviving by assigning these corporations responsibility to respect human rights. But I must say the corporate accountability aspect is an uphill task, as you will hear continuously as we go on. But something has changed. As we have been struggling to survive, the ground has seriously shifted in the digital age. The company, as we knew it, the physical company, has morphed. In some instances, it's no longer physical like we knew it. It's not looking for territories. If you expected labor violations or land evictions, that might not be happening in some contexts. Then we have other companies that, yes, they continue being physical, but they also have virtual operations. And in the virtual space, they control things, sometimes with our knowledge and sometimes without our knowledge, as the people as well as the government. You know, in this day and age, you'll find algorithms are deciding who gets the job. They are able to shape public opinion. In some instances, they even control elections. In Kenya, there is a famous phrase of vifaranga via computer, for some of you who might know it. And this just gets to show how the corporations in the digital age, they really control everything, and they really have a lot of our data, a lot of our information. Some joke sometimes and say they know us even more than our spouses because they are collecting a lot of data. And they collect this data and use it for business. And like I mentioned, sometimes it's without our knowledge. So then it begs the question, how do we navigate protection of human rights in this digital age? We were just trying to catch up with the physical corporates, but then now it's the digital age. How do we go about it? Do we need to go back to the rule books and redraw it, probably assigning businesses additional responsibilities? That's something that probably at the end of this conversation you might be able to speak on or figure out. And like Sarah had mentioned, my task is to take you through the evolution of business responsibilities in human rights. And to tackle this, I would first want us to unpack the business and human rights puzzle, and then proceed to understand the shift from state-centric human rights to corporate accountability, and then finally explore the East African legal system. How does it engage with business and human rights, and especially in the tech industry? All right. So the business and human rights puzzle, what is it? What does it entail? I would say simply it's about balancing corporate growth with the human rights protections. It's about figuring out how do we make businesses respect human rights And as I go on, you will get to understand this more. So most of the times you find that the corporate power is too much and human rights need protections. And so there are always constantly tensions and gaps. How do we bridge this tension? That's the business and human rights puzzle. As I speak, it might sound very easy, but in practice, it's quite an uphill task, I repeat. And how do we find ourselves here? Now, corporations are a necessary evil. I'm sure you'll agree with me on that. We need them. You know, they make products that make our lives more efficient, more convenient, more bearable. In some instances, actually, they drive the economic growth. But the question that begs is do they always do it in a fair manner, or is it just profits for them and everything else is disregarded? They come and they fill the gaps that are left by the state in terms of service provision. But who are they accountable to? It's not to us. Whatever they do, they're only accountable to shareholders who are a small group of people. And these corporations also just respond to incentives and not necessarily to ethics. So, and as we go on, you'll find out that these corporations, it's a system that we created, but at the time of creation, we forgot to limit their powers. And that's why you'll see the constant tension, push and pull between businesses and human rights. So we got to the stage that we are trying to limit the power of the corporations. And that's why you will hear terminology like shifting from state-centric human rights to corporate accountability. Essentially, that means moving the responsibility to respect human rights from the state and extending it to businesses too. But to better understand this, I would want us to take a journey back to understand where the corporate accountability clamor started. And I think I would comfortably start from the era around the 1940s to 1960s. And this is around the time when the World War II had just ended. And the world had witnessed massive human rights violations, genocide, torture, you name it, the Holocaust. And the world was coming to a realization that absolute state power had to be limited. And so you will find that the International Bill of Rights, as was crafted at the time, was only designed to limit state power. And so if you read the ICCPR, ICSR, the UDHR, you'll find the duty of the state to respect, protect, fulfill, and promote human rights. But as all this was going on, behind the scenes, there was something that was happening in the world of business. Now, we had industrial revolution that was already happening. And if you read your history, people were working in really dilapidated conditions. But probably at this time, the human rights violations had not been labeled. We also have around 1885 when the British Limited Liability Act was enacted, and the company was created as we know it, and it had unlimited powers. And also the corporate personality of the company was established under this act. And you remember it was buttressed in the Salomon versus Salomon case. And some people argue actually this corporate personality became an enabler of human rights violations by corporates, because now the business owners were able to remove themselves from the corporate personality, and they, having removed themselves from the corporate personality, they were also able to abandon the economic and moral obligations. That's, however, debatable. And aside from that, we have colonization coming in also. Around 1884, we have the Imperial German East African Company, as well as the Imperial British East African Company. These companies had been given the power not just to govern the British and German protectorates at the time, but they had also been given the power to explore and exploit resources in the East African protectorate. And so they went on building the infrastructure, establishing the plantations. And here again, we could see there was human rights violations. But in that context, probably there was, much as people were clamoring for their rights, it hadn't been recognized fully, all right? But something then happens in the 1970s to the 1990s, we have expansion of global trade and investment. And what this did, it accelerated the rise of transnational and multinational corporations. And we saw these multinationals and transnationals moving to Asia, to Africa, to the Latin Americas. And they were really enjoying the liberalization of trade and investment at the time. As another enabler was the technological advancement. Now, air travel as well as communication had been made easy. And as part of the strategy of these MNCs and TNCs was to now capture the global value chain from where the raw materials are in the global south all the way to production in the later stages of the supply chain. And here again, now we see these so much human rights violation from the capital exporting states mated on residents or people, citizens of the global south. You see there's labor rights violations and environmental rights violations, you name it. And this is the time that globally, around now 1974, globally, there is now a move, accelerated advocacy around corporate accountability. But remember, the companies had started operating way back and they had unlimited powers. But it's only in 1974 that the law is now starting to play catch up. And there is an attempt to retrofit human rights in a system that was initially not designed to prioritize the human rights. And so slowly by slowly, we have moves like in 1974, there was the International Commission on Transnational Cooperation, which created a code of conduct for businesses. And it had 10 principles around human rights, labor, environment, as well as anti-corruption. But again, this was, it was a code of conduct. It's not binding as well as voluntary, and majority of the states would not want to abide by it or subscribe to it because it would have an impact on their profits. They were not going to pay people well because that would impact their profits. They were not going to buy people maybe, what would I call them, PPEs, because that would impact on their profit. They are not going to take up measures to avoid environmental pollution because, again, their profits matter. But then again, we have the UN Global Compact, which is developed in the 2000s, also having principles around human rights, labor, but again, another voluntary code that the businesses might not necessarily subscribe to. In 2003, we had a subcommission that was established by the Human Rights Council of the UN, and this one developed a norm on responsibilities of transnational corporations and other business enterprises with regards to human rights, quite a mouthful. And this one, it's actually the precursor of the UN guiding principles as we know them. These norms on the responsibilities of transnational corporations was rejected by the business community, and largely because it provided a lot of responsibilities to the businesses. It did not only require the businesses to respect human rights, it also required them to protect, secure, and fulfill the human rights within their spheres of influence. This was pretty much assigning them responsibilities similar to what the states have. And so they were not going to have any of that. They rejected it, citing a lot of issues like it's not clear and among other things, but really they just did not want the additional responsibilities. And so having been rejected in 2003, 2004, we have the Human Rights Council again commissioning now the establishment of the UN guiding principles on business and human rights. It can be argued that these the UN guiding principles, I'll refer to them as the UNGPs, they are a watered down version on the norms and responsibilities of business and human rights. They only require the state, rather the corporations, to respect human rights. human rights, they do not also assign these other responsibilities to the corporations. And that was, I would say, it was a good compromise. At least we had something now, something that was acceptable by the businesses. Because, the Swahilis would say, heri nusu shari kuliko shari kamili. Better have a loaf than a full loaf. So at least we had something to work with globally as compared to the initial instances where we just had sectoral norms here and there. And what do the UNGPs provide? It's a 3-pillar framework that provides for the duty to protect, respect, and remedy. So the duty to protect lies with the state. It requires the state to protect individuals against abuses by third parties, including businesses. So this would essentially entail developing and enforcing laws that require businesses to respect human rights. Aside from that, oversighting the corporate behavior as well as providing access to remedy mechanisms and addressing any governance gaps as and when they arise. Then we have the corporate responsibility to respect. This requires the corporations to avoid infringing on human rights and as well as address the negative impacts which they are involved in or they either cause or contribute to. And one important factor in the UNGPs is the establishment of the human rights due diligence process, which requires corporations to, assess the actual and potential human rights impacts, and then develop measures to mitigate these likely impacts that they would have. Then we have the pillar around access to remedy, which requires that when rights are violated, those that are affected should have access to effective judicial and non-judicial mechanisms. And this remedy, I would say it's two-pronged. It has responsibilities for the state as well as for corporations. For the states, they should ensure that the courts are accessible, are impartial, and are capable of handling business and human rights matters, as well as creating non-judicial mechanisms. Then for the corporations, they should establish a grievance mechanism at the operational level, as well as engage directly with the communities in designing an accessible grievance mechanism a mechanism that is culturally appropriate. That's very important because if it's not culturally appropriate, no one is going to use it. Okay. I would have wanted to go on to the developments that have gone on post the RAGI framework, the UNGPs, but I don't know whether time is on my side. I think I'll proceed to the next issue, and if time allows, I will come back to the progress that has been made so far around the establishment of a binding treaty on business and human rights, because again, the UNGPs are soft law. So
Thanks,
then,
Aki. Yeah, you have just 1 minute left, and then we'll proceed to the next speaker and come back on the new developments on business and human rights.
yeah, so let me speak to the East African context. How has it fitted the RAGI's framework in its legal system, especially when we are looking at the application in the tech industry? We have social media, AI, a lot of runaway technologies with us. In terms of the state duty to protect, we are seeing that there's a lot of laws that have been enacted in our different jurisdictions, but fundamentally we have the Constitution, which has enshrined a couple of human rights. Then we have legislations around cybersecurity and data privacy. At least there's Kenya, Uganda, Rwanda, and Tanzania, which have developed laws around data privacy and cybersecurity. The laws, especially around data privacy, are really molded around the EU GDPR. Then we have legislations that are protecting other human rights around labor and other rights. Because remember, when you're talking about the tech industry, it's not just the right to privacy. There's labor rights, there's freedom of conscience, freedom of expression, you name it. And these laws, what they do is that they define the rights of the people as well as the responsibilities of the businesses and how the businesses should conduct themselves. And the state oversights the implementation of these laws. For data protection, we have the Office of the Data Protection Commissioner, established in the different jurisdiction. In terms of access to remedy, just very briefly, we again have the offices of the Data Protection Commissioner in the different jurisdictions, and they really speak to the implementation or any disputes that arise around the Data Protection Act. But we also have our courts, which are another avenue within which people can ventilate their claims, not just on data protection, but as well as negative impacts that the tech industry has had on them. I think my minute is over, so I will stop at this point. And yeah, we will continue with the engagement. Thank you very much for listening.
Thank you, Aki, for that elaborate presentation and taking us through the history of corporate accountability, right from, I think you started at 1940. It was a very good history class. So allow me to now hand it over to Dr. Hannah, who is a technical advisor at CIPESA, which is the Collaboration on International ICT Policy for East and Southern Africa. Dr. Hannah, can you hear us?
Yes, I can hear you. Can you hear me?
Yes, we can. Great. So just on your presentation on gender governance and the digital divide and navigating human rights in the age of ICT. And the main question is assessing how digital platforms have exacerbated human rights violation, particularly gender-based issues and issues related to data security. But also allow me to just add that I understand CIPESA is doing quite a lot on business and human rights in the digital space in Uganda. So maybe you can add a little bit of your personal experiences from CIPESA on how you're doing this for the sake of the audience. Over to you, Dr. Hannah.
Thank you very much, Sarah. Originally communicated to Gabriel that I actually no longer work with CIPESA. I used to work with CIPESA only up until recently. But while I was at CIPESA, we were definitely actively involved in a project on business and human rights. And that was basically focusing on advocacy, bringing together different stakeholders in the business space, and basically deliberating on various ways in which, one, we can not only hold business owners accountable and make sure that they are responsible and responsive to the needs of the people that they serve, but then also educating essentially the citizenry on what their rights are business-wise, what they should expect, when they participate on digital platforms, or what they should expect, especially when they're conducting business on some of these digital platforms, how they can hold, the owners of these digital platforms together and essentially more or less co-create and find and come up with policy decisions that are basically grounded in the context of the people or the main users of some of these systems. And I think that is still ongoing and going on quite successfully. I think perhaps just to move on then to my presentation or brief presentation in terms of the digital divide and how it relates to gender. And of course, here I would possibly be talking about also the gender digital divide in essence, just to basically gender it if we would like to do so. But I'd also want to begin from the fact that the digital world, as we see it right now, created what I properly want to refer to as another space in which we see a lot of gender dynamics. So previously, we had, of course, two spaces, and we still have two spaces in which we essentially see women being marginalized, or we see a lot of dynamics going on gender-wise, or in terms of the gender relations between men and women and other genders, if we so choose to add. And that's basically the private or domestic space. And then we have the public space. And here we essentially recognize the fact that women face a number of, inequality at the private space, which in many cases is replicated into the public space. The gender biases that happen at the private space or at the domestic space, some of them are those that actually get replicated in one way or the other in the public space, either through a transfer of norms, or through living in a shared society where you have similar culture or shared norms, you have similar gender biases, stereotypes about women's involvement in the public space, women's involvement in business, for instance, and women's involvement in the economy. And so those are what in many ways affect women's advancement when it comes to the public space. Now, what technology did is that it amplified the public space, or rather, we can even think that it did amplify both the private and the digital space, the private and the public space. So you find that women now are not just dealing with the private or domestic space and public space, but they also have to deal with the digital space. And of course, some of the challenges that women face are some that we're familiar with, which include, for example, cyberbullying, online harassment. Some of them, like online harassment, is something that still happens offline. But again, it's in a very similar way transferred onto the different online modes. Then you have, of course, aspects of cyberbullying. Cyberbullying is bullying online, but bullying still happens offline. And so its characteristics are pretty much similar, although now they take on different, characteristics or connotations when they pick on the online legs, so to say. One of the most, of course, recent ones that which we seem to be more cognizant of course, is the one of non-consensual sharing of intimate images. Of course, that in one way becomes more of the downsides of the internet, infringement on privacy, where people no longer know what is private information and what isn't private information. Some of it, of course, is shared, maliciously and basically with an intent to cause harm or damage to one's reputation. And with women, it's obviously, given the fact that in many other spaces, women tend to, face biases that are often sexualized. These, in a way, have an impact on their, outlook, and have an impact on their progress in society, have an impact on their productivity. In terms of the barriers to women's access to, for instance, information technology, and the ways in which perhaps they can be able to, empower themselves to actively participate in it. Of course, we recognize the fact that there's the obvious one of literacy. And the obvious one of literacy, again, I still go back to my starting point that what happens online is more of a replication of what happens offline. When we look at the offline space in terms of both the private and the public, and also the fact that it's in many ways is affected by society and cultural norms, we talk about, for example, education, and in terms of gender inequality, who has more access to education, who has more access to information. And when you look at, basically, even if you would like even just to do a cursory analysis of what happens in these education spaces, you find that it's more men compared to the women. Transfer that into the digital space, obviously it replicates itself into the digital space. So whereby in digital literacy, it's women who will have less access to some of these opportunities to acquire knowledge about how to use some of these digital spaces. So hence, they'll suffer more from digital illiteracy, which in many ways will act to their detriment. Of course, there's the other aspects of gender bias in technology, which, of course, again, like I said, still stems from the public and the private space offline, and is obviously transferred into the digital space. And, you look at, for instance, examples of where if when we first had, AI voice prompts and readovers, the fact that your phone or even just your system will most likely pick up more of a male voice instead of a female voice to the read on, the read over. I mean, that in one way, also affects, so you feel like you are not part of this world. You're just trying to incorporate yourself into the world. Again, a replication of what happens in the offline space. Again, we see it on the online space. The aspects of online safety concerns are not any different, again, from what happens offline. Women, face a lot of safety concerns when it comes to offline spaces, but also when it comes to online, most of these are replicated. People have the ability to be harassed. This technology has created the ability for women to be harassed online. They create the ability for even to be for women to be sexually abused on an online space, knowingly most of the times, and even unknowingly. Also create the ability for one to actually be manipulated, and before you know it, you have actually been sexually harassed online, but you weren't aware of some of these undertones. And that is where actually the awareness is important, so that women can be able to notice some of these undertones, to be able to notice some of these the ways in which these technologies work, and they can be able to protect themselves moving forward. I think for me, at the end of the day, in terms of what is the way forward and what we should do in order to protect women when it comes to online spaces, of course, one, what's the most important is the literacy. Basically educating women on how to use these digital spaces, but then also on how to be able to navigate and to be able to protect themselves once they're operating on these digital spaces. And of course, the fact that part of the literacy comes with the awareness of knowing, what are your rights, when it comes to your online participation, what laws are out there to protect you, how can you use them, what avenues are available for you to be able to safely, for example, uh, log a complaint or a grievance, against a service provider or against an actor, against a stakeholder, and be protected, from retaliation in the event that, they perhaps get to know who you are. That, in a way, I think will go, obviously, the long way in ensuring that the gender divide when it comes to technology and the digital spaces is reduced, of course, for those who are able to access it. But again, we have to recognize the fact that with those that are able to access it, we also have those that aren't able to access it, which in most cases becomes is a bigger percentage. So now what do we do with them? What kind of remedies do we offer? What kind of strategies can we offer for them? Of course, that comes with the fact that um, government definitely has to be responsive, to the needs of the citizens, and ensuring that some of these technologies are actually made available and accessible to women at an affordable price or an affordable rate. But again, we cannot avoid the fact that when we talk about the gender divide, and then going back to my original starting point of the fact that we need to recognize gender dynamics both in the private space and in the public space, and the fact that what happens with the gender dynamics and relations in the private and domestic space get repeated in the digital space, is that women's, for example, when it comes to the double burden that women have to undergo, or that women have to face, especially in terms of their care duties, that in a way, if we don't find a way of reducing that, and if we don't find a way of monetizing the care work or the time that women spend in what is probably referred to as unproductive work that doesn't necessarily bring in money, then our road to also access becomes limited, because if women spend most of their time in care work or unproductive work, then they'll have very limited time for them to engage in the digital space. So for me, I think it's the gender divide um, issue is quite comprehensive. It cannot just be addressed by one law. So, for example, a human rights law, it cannot be just addressed by addressing a privacy aspect. It's more comprehensive in nature. It's got to have more of a 360 view, looking at both the societal and cultural norms, looking at the gender relations and the biases and stereotypes, and how we can address all of those to ensure that we ensure that women are put in a better place for them to be able to participate effectively, for them to be empowered to participate and be able to take care of themselves, demand for their rights in case they are violated. But then also ensure essentially that we have protections, put in place to protect women from some of these violations moving forward, and not forgetting the fact that the world is not just made up of women, it's made up of men too. So all stakeholders need to be involved in ensuring that the internet is safe, the digital spaces are safe for both men and women, and it's not just a one-sided affair moving forward. Thank you. Over to you, Sarah.
So much, Dr. Hannah, for that overview. And maybe during the Q&A, we can discuss more on this question of tech-facilitated sexual violence and the move that some countries in Africa are witnessing right now, the review of sexual offences law to include this as a specific offence, and your views on whether this is the right move for a government-led law or government-led initiative to criminalize violence happening online, or whether it should also be the role of companies such as Meta, for example, in ensuring content moderation and ensuring that women have a safe space online. I see there are some questions related to that, but we will come to that. One of the questions relates to protection of children. I think this is something you might speak on, Dr. Hannah. But we now move on to our last speaker, who is Ms. Njile Bwana, the co-managing partner at KKB Attorneys at Law. Ms. Njile, can you hear us?
Yes, I can.
Great. And your presentation will mainly focus on the opportunities and challenges for legal practitioners in East Africa. Some questions that I've seen on the chat relate to the issue of access to remedy. How effective is that in certain countries in East Africa? How can lawyers use these opportunities in litigating in courts? And also the issue that we discussed earlier with Ms. Aki on the non-judicial remedies. How do we as lawyers effectively use these remedies? So, over.
Okay. Thank you so much for the opportunity. So I will touch base on the opportunities for legal practitioners in East Africa. So basically, right now, with the emerging expansion of tech sectors or technology in Africa or East Africa in general, so it brings the opportunity to lawyers as well. As much as there's so much challenges, but also we have opportunities. So I will start with the opportunities and I will touch base on the challenges. So the first opportunity, number one, is the emerging legal markets in tech and human rights. Because with growth in tech, meaning there's e-commerce, there's AI, it creates a demand for legal expertise. For example, in Tanzania, we have a lot of clients who are recently asking for legal opinions, especially, for example, on issues of new data protection laws. Of course, we've seen this has cut across Kenya, it has cut across Tanzania and the whole of East Africa. So now, of course, the opportunity is that there's a legal market in tech and human rights. So lawyers have opportunity to advise and issues like that, but also there's so many cases that are coming up, especially on issues of data protection or cybersecurity. We've seen some in Kenya that has even been ruled in favor of the people. So that is one opportunity. But then we have, of course, the policy and legislative development, where, of course, lawyers can influence actually the lawmaking and participate, of course, in shaping the digital rights framework. So, of course, my colleagues previously have talked about, of course, the freedom of expression, or maybe of course, cyberbullying, where people are affected actually, and they are not able to actually speak up. But with of course, the growth of technology, then of course, we have opportunities as lawyers actually to influence the lawmaking. So this is another opportunity where lawyers can actually do it, influence the lawmaking in shaping now how this technology can help people instead of becoming a challenge. Because, of course, my colleagues have mentioned issues of AI. The use of AI has become a problem because people now misuse it. But then if we as lawyers influence the ethical use of AI, it can be an opportunity for lawyers actually. But also we have the cross-border and regional collaboration. We have, of course, for example, the East Africa community laws, for example, in customs, where recently, for example, in customs, they have done a lot of changes in the systems. So, of course, lawyers get opportunities there because, again, there's more opportunities for cross-border collaboration because number one, because of changes in the systems. So now clients are becoming more conscious, especially on issues, for example, like intellectual property. So now, for example, recently in my firm, we had this opportunity to actually collaborate with law firms in Kenya on intellectual property because clients now are becoming more conscious. So they want to register their products or they want to register their brands with the growth of technology because people can start counterfeiting their products or they can start misusing their products. So now this gives an opportunity for lawyers in cross-border to actually collaborate together regionally, but also in East Africa. But we've seen, of course, with the custom laws that are cutting across the whole of East Africa, it brings about collaboration because, for example, I can give an example. We recently had a case where we had a client who was in Kenya, but then again, he's in Tanzania. So we had to give a scenario where it happened in Kenya and we used that in Tanzania. So it worked in our favor. So something like that can happen because it's bringing the collaboration, but it's an opportunity as well. But then, of course, we have opportunities in litigation and strategic human rights cases. Of course, based on, of course, we've talked about a lot of things, especially on issues, let's say, of AI or freedom of speech or things like that. So those bring opportunity for lawyers on litigation and strategic litigation on several issues, like, for example, online censorship that has been spoken about or discrimination that has been spoken about. So these are important cases that create precedents that lawyers, of course, have an opportunity to handle. But then again, we have an opportunity in the corporate advisory services. Of course, I've heard about the issue of human rights that has been spoken by my colleagues previously. Before now. And of course, we understand all the challenges that come in where corporations are looking about the costs vis-a-vis doing the right thing. So of course, advisory to lawyers opportunities does not only apply to only the big corporations. So this applies to also people who are affected. So of course, lawyers can advise, of course, on human rights due diligence, but also labor practices, the impact of these digital platforms. So all these opportunities where lawyers can actually get, of course, business and can get opportunities to handle. But then I will speak about the challenges as well for legal practitioners in East Africa in navigating, of course, the business and human rights in this digital age. So number one, we have, of course, the weak enforcement mechanisms where, of course, as Africans or as East Africans, of course, I can let's say I can applaud our government for actually working on changing the laws or actually implementing or creating laws that are going to actually govern the technology or the growth of technology in our countries. But then the enforcement mechanisms are very weak or they're very, very hard to actually enforce. And for example, we have the new laws of data protection, where it is a good law, it has a good intention, but then the enforcement of it is a little bit difficult because, for example, in Tanzania, we have companies that now are required to register as data collectors, but also they're supposed to register some as data processors. But then there's an issue of, okay, who is a data collector is clear, but people do not understand. If I'm a dormant company, do I still register for data protection if I'm not collecting? So there's a lot of a gray area where the law is there, but then implementation is a little bit difficult. And you go to these trainings and then you have answers, but then again, there's some gray areas where it's like, okay, what happens if this happens? So of course, it's a growing field, but again, the challenge right now is the enforcement issue. But then all the enforcement is inconsistent because you might go to this government bodies, they would say one thing and then another will implement it in a different way. But then also sometimes courts lack capacity or political will to handle complex matters, especially these issues of technology, or if it involves anything political. So you find that courts sometimes can actually delay, or sometimes it's not always, but I've seen across East Africa, sometimes it can happen where the capacity is not there or the will. So you find that the justice is actually delayed. So again, it can be a challenge for the legal practitioners, because again, you are representing a client, and at the end of the day, it's a little bit stressful on that part. But then we have, again, lack of awareness and training. Because we have limited legal training on business and human rights in the digital space. So it can become a challenge, especially as lawyers, especially young lawyers who are upcoming right now. It becomes a challenge because, again, the lack of training can really impact the outcome. So again, our laws are very complex. They are not clear. So with the gray area law, and then with lack of awareness and training, it really becomes a problem. But then we have practitioners may not be equipped to handle fast evolving issues like AI ethics or those type of regulations. And I can just say that I've seen a lot of lawyers struggle right now to accept that AI is taking over. So again, they're not, because we're so rigid to believe that lawyers can actually be replaced, we're not willing to actually learn or understand how these things work in order to move and be able to know how to regulate or advise how these laws can be implemented to regulate this technological issues like AI that are going to impact, of course, our businesses or how we work. So based on that, we cannot, because it's moving so fast. So because we're not equipped to handle such fast moving issues, then it becomes a challenge. But then we have, of course, surveillance sometimes from, of course, the government, because we've heard a concern. And I can say, for example, last week we had a training on data protection, and then people would ask these questions like, okay, is my data going to be accessed, or things like that. So again, there's a certainty or gray area, like who can access my data. So again, it becomes a question as lawyer practitioners. Sometimes it's very difficult to explain to a client that, okay, is my right really protected, or who can access my data? So again, in the angle of technology and human rights, it can conflict, because again, there's no proper regulation to even regulate some government bodies that maybe would want to overstep that area. But then we have, of course, again, cross-jurisdictional complexity, where, of course, we have matters that are cutting across East Africa. So you find, for example, as East Africans, for example, Tanzania, Kenya, and Uganda, we do share some East Africa custom laws. But again, you go to Tanzania or you go to Kenya, they say, this is not how we do things. Sometimes it can conflict what is already written as a law. Or sometimes we can have conflicting laws that are going to, again, impact the business or the implementation of these laws. But then again, we have data transfers. Like I said, we have issues that are cutting across the borders. So how do we control that, or how do we manage? Because again, we don't have general laws that are governing, the technological issues that are cutting across the borders. But again, jurisdictional challenges in litigation in case of issues that are cutting across borders. But again, as my previous colleagues have mentioned, sometimes, these clients or big corporations, they are reluctant to prioritize human rights. And they find it as optional. And I can testify that I, for one, as a lawyer, in my experience, I've had to explain to clients so many times. Sometimes we even question, like, are they trying to maybe test my intelligence? Because it's something like, you see that it's clearly written, it's someone's human rights. And I can give an example. For example, I had a client who hired a lady, and then the lady said, I am pregnant. So he said, I don't want to continue working with this person. So again, it's a human right of a person, but then it's coming across as if it's something that they should beg for. So many businesses are profit driven, and they do not see the human rights compliance. So they find it maybe costful. So this is a huge challenge as lawyers, especially if you have to explain to your clients, because again, it also brings me to my final challenge, that ethical dilemma. Like, as a lawyer, you have your duty as a lawyer or as an advocate to uphold or to make sure that this client or the law is followed. But then again, you have your clients, who again is your business. So a lot of lawyers find themselves in ethical dilemmas because, again, clients do not want to prioritize, especially the human rights compliance. But also, lawyers face a challenge to educate their clients on long-term legal or reputational risks. So you find yourself trying to talk to a person that does not want to understand you. So this is a huge, huge challenge, especially in this topic of navigating, the technology, human rights, and business. But also, like I said, my last topic is ethical dilemma. So legal professionals, sometimes they face situations, like I said, where the interests of their clients would clash with the human rights. So you have, as a lawyer, to do the right thing. But we've seen sometimes lawyers choose not to, because, again, it's business. But again, lawyers forget that they have a duty as lawyers to make sure that they follow their ethical duty as lawyers. So that dilemma, most of the time, it becomes a challenge because, again, as lawyers, we're supposed to be the first people to implement these laws or to make sure that they are followed. But again, when you're advising against sometimes governments, or you're going to meetings with your clients or against the government, it becomes a question of, okay, you are a lawyer, so sometimes lawyers are afraid. They're afraid to say the right thing because maybe, someone will take it the wrong way. So this becomes a huge challenge in really navigating this. So in short, this is my presentation, and in case of any questions, I'm happy to revert.
Thank you, Ms. Ndile, for that elaborate presentation. And we are now at the Q&A stage. I see there are 2 questions on the chat by Milkias, and we have one, I think, by Lillian. So I'll start with the first question by Milkias, and the question relates to how should we assess the responsibility of law firms that provide services to companies implicated in human rights abuses, especially when these corporations use powerful law firms? And the second part of the question is, should a law firm withdraw its professional services upon concluding that its client is involved in human rights abuses? I'll allow Ms. Aki to answer this, but I'd also want to get insights from Ms. Njile, because you mentioned something on ethical dilemmas, and this touches directly on the ethical parts, the second part of the question. So Aki and then Njile.
Thank you, Sarah. That's a very good question, and it speaks to the dilemma that most law firms find themselves in. And I think Ms. Njile has spoken partly about it. But at the core of this question is responsible lawyering. One, you cannot abandon your client at the point of need. Remember, as a lawyer, you have a duty to your client. So you cannot withdraw at that point. In my opinion, it would take changing of tactic, all right? So that you move from a client-centric approach in addressing that matter to the wider justice approach. But I know at the heat of the moment, at that time when the violation has taken place, it will be very difficult for these corporations to listen to you. They would want you to actually go and defend them and secure a win for them. But you also have to look at the bigger picture. Sometimes a win in court might not be a win in the court of public opinion, might not be a win in the consumer market. You might secure a win in court, but with this cancel culture, again in social media, some people might boycott your products. You might suffer reputational risks. Consumers might refuse to consume your products because they can clearly see that there is a human rights violation. And this is much as you have secured a win in court. So as a lawyer, you have to look at the bigger picture, not just the client's need, but also the wider justice approach. And what does this call us to do then? You, as a lawyer, again, you should not just be reactive, that you wait for your client to come with a human rights violation, then now you start acting. No, you have to be providing advisory to the client at all times. So really it calls us to mitigate the human rights violations. That means you're educating your clients. When a new law comes up, you educate the client in case there is a requirement, there's change in requirements, let them know what they're required to do. Support them in doing the due diligences. From time to time, you can even conduct audits on them to see their level of compliance so that they don't find themselves in the violations. So it's just a matter of changing tact rather than withdrawing. Thank you. I hope that answers the question.
Thank you, Aki. Njila?
Yes, just to add what Miss Aki said, as lawyers, of course, again, as Miss Aki said, you have a duty to your client. And again, your client also has the right to be represented. Again, that's also their human rights. But I am a firm believer that as lawyers, you need to be able to tell your client the truth. That is number one. And this is where, as the person who asked the question, that big law firms fail sometimes because, again, there's the business element. Of course, as lawyers, we have to be business lawyers, but also we need to be ethical. And we need to have the ability to tell our clients the truth. I always tell my team, do not be a lawyer who your client tells you what to do. If your client tells you what to do, then for me, it's not the right relationship. You need to be able to exit that relationship because as a lawyer, your role is to advise the client. And as Aki says, that you need to not be reactive. You need to be able to ensure that your client understands the law. They understand the repercussions of their actions. They understand that if they do 1, 2, 3, then they have to do this. And for me, I am also a believer that if you as a lawyer has done your part, then it is okay to walk away, especially if your reputation is at risk. Because again, today, for example, I do not believe me as a lawyer or as an advocate, I can watch, let's say, my clients violate the law, and then I have explained or have advised several times and they have ignored my advice, then of course respectfully, of course I know also my rights as an advocate, then I can respectfully walk away from that relationship. So sometimes it's doing the right thing as you are upholding your ethical duty. So I don't think you can cast away the law firms that are working for these clients because again, we do not know, maybe they've tried to tell them, but again, it's a situation of being able to tell your client the truth, that you need to advise them that this will not work, or maybe, yes, you will win, but again, there's a reputational risk. But then as well, we're business lawyers, so that has to be in line. So if you tell your client the truth, then I'm sure any reasonable client or professional, they will definitely take the professional advice. But again, it removes your professional liability in the future.
Thank you, Ms. Njile. We also have a question from Lillian. What's the law's contribution on protecting children from embarrassment and public ridicule in the digital space? And this relates to a TikTok trend that, interestingly, is called the useless things I got for my child. And mothers are posting deadbeat fathers. And is there a law, over to you, Dr. Hannah, is there a law to protect children from such kind of exposure because of the long-term harm?
Thank you, Sarah. Yes, there is a law, but I think my colleagues on the call also probably chip in a little bit more from their practice and experience. Of course, African governments or countries pledge to basically assent and ratify to certain international, a couple of international laws. Of course, some of them include, for example, the United Nations Convention on the Rights of a Child, which basically aim to protect children from all forms of violence. And of course, key here is all forms of violence, abuse, neglect, or exploitation, which I think obviously in the age that we're living in is being extended to include violence that happens on digital spaces. Many countries, including Uganda, have ratified this convention. And then also, of course, in many ways, there are other laws that, for example, in Uganda, that, such as the Computer Misuse Act, that in many ways attempt to, although with a few limitations or inadequacies embedded within, but in many ways attempts to protect not only children, but also people from, for example, malicious content that could have been put online about them, to the extent that that content can actually be taken down. Of course, again, that is more of a reactive kind of mechanism. And as someone can say, well, the information is already down there. For example, you can put up a tweet, it can be taken down, but people have the ability to, for example, screenshot it and keep it for future purposes. And of course, there's also the fact that information really never gets deleted from the internet and on technologies, and that it can be retrieved best and depending on when it is required and when it wants to be used. However, I think at the end of the day, the reactive mechanisms, especially legal wise, are still important to protect children in one way, and also to ensure that their well-being is safeguarded at the end of the day. And I think that's the reason why some of these laws are present, and they can actually be used to, for instance, punish perpetrators. But again, given the fact that I said that they are reactive, the other thing that we also need to fall back to, also, or rather to emphasize, is your personal responsibility, essentially, towards protecting children and other marginalized people from abuse, for instance, online. And I think it's our responsibility to, for instance, if these things are happening, to call out the perpetrators and to make sure that they are accountable, even when for example, the tech companies and are trying to ensure that they put in place protocols that ensure that such information that is harmful to the well-being of children is taken down eventually. We obviously know it continues to happen, but at the end of the day, personal responsibility and looking out for one another, I think, in society is also very important. But then again, also, the fact that you asked about these laws also points to the need for more education and awareness about the various ways in which people can actually protect themselves, because you realize in social relations and even in families there's a bit of a power dynamic, and obviously for children, they may not be aware of the protections that they need or be able to actually protect themselves. But if they have kin that are aware of some of these laws and aware of which officers they can reach out to get redressed, then that also is important. I think this is where the CSOs and come into play, to basically create awareness and advocacy, and of course, such spaces like the one we're on right now. Yeah, thank you.
Thank you, Dr. Hannah. And now to the last question, again by Milkia, and it ties on to something that you are supposed to address, Aki, on the next steps on the UN guiding principles, the binding treaty. There is a discussion, Milkia, on a binding treaty, but I'll hand it over to Dr. Aki on how that binding treaty will bridge the gap on corporate responsibility.
Thank you very much, Sarah. Thank you for the wishes for me to become a doctor. I am just Miss Aki, not yet obtained.
Yes, Miss Aki. But again, yes, you gave us a good history. So Dr. Aki, for now.
Thank you. Thank you very much. Now, on the treaty, can it be able to bridge the gap on corporate accountability? This is a very interesting question that I cannot give an authoritative, firm answer. Now, just a bit of information about the treaty. Again, history. In 2014, the Human Rights Council passed a resolution establishing an open-ended international working group. And this working group had the mandate of establishing a legally binding treaty to regulate the activities of these transnational corporations. And the background of this was that a lot of victims were struggling to access justice from the the multinationals and the transnationals, and especially due to jurisdictional barriers, the issue of the corporate personality, and most of them do not have money. And it's very interesting that most of the places where you see these human rights violations, the victims are usually very poor. So this binding treaty attempts to enhance corporate accountability by now bringing down these jurisdictional barriers. For example, it provides that it provides different avenues through which victims can access remedy, and this can be the state which hosts the corporation. It could be where the mother company is domiciled, and it could be anywhere where the corporation has operations. So that, and I know recently there was discussions, especially in Kenya, around Meta. There was a jurisdictional issue as to whether Meta can be sued in Kenya, or it just has to be sued in what is it called, where the company is incorporated. And thankfully, the courts in Kenya ruled that it can be sued in Kenya. And that just goes to show some of the jurisdictional barriers that these people whose rights are violated face. So those are among the things that the treaty is looking to address. Now, I wouldn't say that it's entirely going to bridge the corporate accountability gap. I would say it's a step in the right direction. But remember, this process for the binding treaty started in 2014. A decade down the line, we don't have a binding treaty. And this has a geopolitical context to it. This binding treaty is being pushed by the countries from the global south. Is it likely to get support from the global north? Are the states that, especially in the global north, going to ratify it? We don't have the final text yet, but at the point that we have the final text, will it be ratified? Will there be a buy-in by the corporations? Because now they have to be held accountable. So these are some of the barriers that the treaty has to pass first before we can say whether it will be able to ensure corporate accountability. And then there is also the aspect of now implementation. Once it passes all this, will it really be implemented? Yeah. So it's still very hazy at the moment, but I would say bottom line for corporate accountability to be guaranteed, it really has to start with the states. The states have to really take forth their responsibility to protect their citizenry. No amount of treaties, in my opinion, can ensure corporate accountability. The buck stops with the state, in my opinion. And yeah, so the treaty will come. It's a step towards the right direction, but more still has to be done. But aside from that, we are already seeing, as we await the treaty, we're already seeing some moves by some countries in trying to protect the human rights of people, especially countries in the EU. For example, we have the France Duty of Vigilance law. It already provides that a company that is incorporated in France can be sued for violations that it has perpetuated in another country. So you can have a citizen of Kenya, for example, suing a French company for the violations it has meted on citizens in Kenya, but in a France court. But then again, the issue of cost comes in. It again becomes a hindrance towards access to justice for the victims of the human rights violations. Other countries such as Germany and the US and the UK, they also have this. And we have actually tested this system even in Kenya, not necessarily in the tech space, but I would give the example of Kakuzi, which is a company, an agri company in Kenya that has been sued for the violations of for the human rights violations in Kenya, but the suit has been taken to the UK, where the mother company is. So those are some of the extraterritorial jurisdiction, I would call it. Those are some of the mechanisms that are currently being put in place, which the binding treaty would also buttress. Thanks.
Thank you so much, Aki, for that presentation and elaborating on that point on the binding treaty. And just to mention, the African Union also has a draft policy framework on business and human rights, which has been in the draft stage for a very long time. So we cannot tell whether it's going to be adopted anytime soon. But I think it's one step to having something binding in the region. I don't know if I am locking anyone else. Yeah, sorry, Akid, you wanted to mention something?
Yeah, probably just to mention also the African Continental Free Trade Area Agreement. In the investment protocols, there's also an obligation for states to ensure that they have laws around business and human rights. But it becomes very tricky again because you find that these countries want to attract investment. So they are likely to relax their laws so much so that they can attract investment. Remember, the businesses do not want to spend a lot protecting human rights, something that would jeopardize their profits. They do not want any of that. So there's always the tendency of the states relaxing their laws so much, unfortunately, to the detriment of the citizenry. So it will have to be a balance. We are waiting to see how it will play out. Will they choose investment over the people? It's really a puzzle, like we started by saying.
Exactly, yes. The FCTA is a controversial law regarding business and human rights. We have one last question from Otto, and allow me to hand this over to you, Njile, as a practicing lawyer. How can evidence be effectively gathered and presented in court when human rights violations occur through opaque digital systems or in cyberspace?
Sorry, maybe I would need more clarity on the question.
So the question is, how can evidence be effectively gathered and presented in court when human rights violations occur through opaque digital systems or in cyberspace?
Okay. So I will just maybe respond in context of Tanzania, because in Tanzania, of course, electronic evidence is admissible. Of course, there's rules or procedures to follow in doing that. So maybe it would be best for the person who asked the question to maybe clarify maybe because I'm giving an example. If someone, let's say, bullied me online, and of course, again, we're talking again if this person is real or maybe this person is fake. So if this person is real and this person can be sued and I can get access to this person, of course, again, I can present the evidence of what the person said. This is just an example. So maybe for me to reply well, like I said, in Tanzania, electronic evidence is admissible. There's procedure to follow in presenting electronic evidence. So maybe to help that person, yes, you can present electronic evidence in Tanzania context, in my experience.
Thank you, Njile.
Just to add on that,
yes.
I don't know whether the participant is Kenyan or Tanzanian, but also in the Kenyan context, just like Tanzania, we have electronic evidence admissible, and indeed there's also a procedure to admitting it in court.
Oh, Otto has just mentioned that he's Kenyan, so
Yes.
Thank you for adding that context. I see we do not have any other questions on the chat or the Q&A box. Gabriel, I'll now like to hand this over to you. Thank you so much to the panelists, Dr. Hannah, Njile, and Aki, for that elaborate presentation, very thought-provoking. Thank you to the attendees for your questions and insights in the chat. And just to shamelessly plug, at Thomson Reuters Foundation, we have developed toolkits on AI governance in Africa, and they also have an aspect of advocacy. So I am happy to drop a link, and we are also in the process of finalizing our latest report on generative AI and freedom of expression that also has an aspect of corporate accountability for tech companies. In case you will be in Zambia this month for the Digital Rights and Inclusion Forum, we will be presenting our findings at that forum. So Gabriel, as I hand it over to you, there has been a lot of discussion on cross-border collaboration, and thank you, Njile, for speaking on that. Gabriel, I think it's time as ELS we think of a session or an in-person training on this issue of BHR in the digital age. So I'm also assigning a task and holding you accountable over 92 people in this call. Yeah. Thank you so much for this opportunity.
Well, thank you, my good friend Sarah Ngachi. Thank you for keeping this session short and sweet. Indeed, it's been a very elaborate and interesting session. We have learned quite a bit from this session. I would like to, on behalf of our CEO, thank you, our esteemed panelists, Dr. Hannah Muze, Ms. Njile Bwana, and the blessing of Dr. Nasanga Aki. Thank you so much for taking off time and being part of this discussion. Indeed, your presentations have not only enlightened us, but they have lit a fire in our bellies for business and human rights in the region. And like my good friend Sarah said, it's about time that we start thinking about an in-person training, and that's a conversation that we can pick up from here. Thankfully, Sarah is from Thomson Reuters, and we do have the expertise. We have people like Ms. Nasanga Aki, Dr. Hannah Muze, Njile Bwana, who are experts in this area. And so we look forward to collaborating with our speakers in the future to conducting an in-person training that will benefit our participants. And so, ladies and gentlemen, it's a wrap. It's our Thursday, which means this is our last session of the week. Be on the lookout for our sessions next week. Next week, we'll be discussing insurance law and trying to assess the legal landscape in Eastern Africa. And we will also have another discussion on Thursday. So I would like to end it here, and the recording of this session will be shared with you on email so that you can be able to access it. Otherwise, we thank you, and we wish you all a very lovely afternoon. You stay blessed, stay safe until we meet again next week on Tuesday. Thank you. Goodbye.
Thank you.
Thank you. Bye.
Thank you.